appearances to the record, please?
Goodrich, Joint County Prosecutor.
Dominic Fantasy Jr. Your Honor, on behalf of Mr. Warner, seat to my right.
All right, and we're here for sentencing that's been adjourned a couple of times. All right, so Mr. Andriaki, have you had a chance to review the pre-sentence report with the clients?
Yes, Your Honor.
And you do you have any additions or corrections or scoring challenges?
No additions or corrections, scoring challenges, and I guess maybe it might be an additional correction, potential issue with one of the victim impact statements. I don't know how you would classify that, but
Okay, well, let's see. I received written victim impact statements from a minor, we'll just use initials for minors, is that
Yep.
right? A minor PW,
yes.
and I received one from this person, that's one of the mothers. I received a letter from defendant's mother.
Correct.
And from his grandmother.
Correct.
So you're not talking about those.
Pause right here. This is a subtle but critical legal moment. Victim impact statements feel emotional, but in sentencing, they're governed by strict rules. The law doesn't ask who feels harm, it asks who legally qualifies as a victim. And that distinction is about to reshape how this entire sentencing plays out.
Are you talking about the one from the adult victim impact statement?
Yes.
What do you want to say about that?
Just that essentially the TW's mother is not a victim. In these cases, she's not a complainant in either one of them. The complainant is PW. Because PW made her own statement and did not designate her mother to be making a statement on her behalf, we would request that that statement be stricken. The adult.
Ms. Goodrich, your response to that?
Your Honor, typically by the statute, I would agree that because the victim statement and typically the consequences go around the mother or the parent to ultimately change it. You don't really have very much.
So I will, obviously I read these when they come in, but I will disregard and strike anything in the impact statement from the victim's mother.
This is the judge drawing a bright legal line. Even deeply emotional testimony gets zero weight. If it doesn't meet statutory requirements for the defense, this is a quiet but major win, because sentencing guidelines live and die by what can be considered not what sounds compelling.
And not consider any of those facts in the scoring of impact.
Thank you, Your Honor.
So I do have the written statement from the minor victim. All right, and so why don't we go? We've got two charges. One, the costing a minor for moral purposes, which is scored in 5 to 23 months, and then using a computer to commit that crime, scored at 10 to 23 months. So maybe why don't we take one objection at a time. So give me one scoring challenge.
Sure. You want to do? We've had a little bit of discussion about these prior ones. I don't know how much you'd like to go over those again.
I guess I'd like a refresher then.
Sure.
So what OV or PRV are you challenging for?
Of course, thank you, Your Honor. We're challenging OV4 and OV. Where's forget the number of it, but it's
OV10.
OV10, yes.
Okay. So let's do OV4 first. That's serious psychological group 2 victim, and that was scored. Well, it wasn't scored in the costing, but it was scored in the using a computer to commit crime.
Correct.
Okay. And you believe that it should be scored at 0 points in both?
Correct.
And Ms. Goodrich, is your position that it should be scored at 10 points in both?
Yes.
Okay. So we're at all or nothing. And do you think that the argument applies to both charges, whether it should be scored or not, it should be uniform.
Well, I don't believe it should be uniform. I believe, basically, I would make, given that the prosecution wants the 10 points for both charges, I'd make, state the argument, say it applies to both. I believe that.
Even if it's scored for the costing, you think you shouldn't score for the computer?
Correct.
All right, so why don't we take sort of level one of that is tell me why it shouldn't score for.
Now we're entering the legal battlefield. OB, for-inch serious psychological injury, is one of the most argued offense variables in Michigan sentencing. Why? Because it can dramatically increase prison time without physical injury. The question here isn't whether harm exists, but whether the law allows the court to blame this defendant for this harm.
For why it should score for each.
Thank you, Your Honor. So OB4 is a offense-specific crime or an offense-specific OB, and that's according to People v. McGraw. So when we look at OB4, and I know in particular it's the victim impact, right? So when we look at the victim impact statement, the complainant or the victim, TW, states that she has started or continued counseling and has increased her medicine for anxiety or some sort of diagnosis based on family members blaming her for Mr. Warner being in jail. Now, because of McGraw, we have to look at what did Mr. Warner do? Did that necessarily necessitate some serious psychological harm in treatment? According to the complainant's, the victim, again, I apologize, the victim's own statement is based on other people putting these pressures or saying these things, not that anything Mr. Warner specifically did. And for that reason, it should be scored at 0 for both of them. The additional argument would be there's no additional fact that because he used a cell phone to text the complainant, that use of a cell phone to commit a crime.
So under McGraw,
Yes.
using a computer to commit a crime would not have resulted in serious psychological harm. So that even if it did score for approximations for computers, that fair?
Yes. Yeah.
But that your broader argument is that even though the written impact statement would support that there has been serious psychological harm, that has not, there's insufficient evidence on this record that has stemmed from sentencing offense, that it has perhaps stemmed from post-sentencing offense conduct by people other than your client.
Correct, Your Honor.
Ms. Goodrich?
Yeah, I think that the being the victim of this offense has caused psychological harm, and being certainly a minor, difficult to explain. That, but for his actions, she would not have to endure consequences of coming forward and being honest and reporting him. It all stems from what he did to her that night, and I think it's just her explaining one of the things that happened as a result of that. She calls him to come at her 3 times prior, and she says, "I told her to help you, I'm not a higher person." And then says that's the employment to blame me. Certainly that's all encompassing of what she said to be doing, and just over him. The device that he used in order to commit the costing was the computer. So, but for him not having a computer available that night, he would not have been able to cost her and cause that psychological injury. So I think that to prove so I think it should be scored 10 points.
Well, thank you. Well, I think what the prosecutor has articulated about the sort of the dynamics of sexual offense against a minor and what they typically experience and how that sort of flows into when other family members don't believe that with them and blaming them, that can compound the harm. I don't take issue with any of that factually at all. As a general matter, and even as a specific matter in this case, However, the case law on OB4 is, I guess, both broad and tight at the same time, or narrow at the same time. It's broad in that the amount of evidence needed to score for serious psychological injury is not a particularly onerous threshold to meet. But there are some limitations. It has to be victim specific, and there has to be specific evidence that that particular victim has suffered a serious psychological injury as a result of the sentencing offense conduct by the defendant. People v. McGraw, the Michigan Supreme Court has cautioned that we cannot consider post conduct that occurs after the sentencing offense is completed. Also, the case law cautions trial courts not to score before based upon sort of these reasonable victim or what a minor would typically experience under this circumstance that the prosecutors articulate. And I don't disagree with any of that as a factual matter, but as a legal matter, that would be insufficient. We did jury sentencing to allow for even testimony if the people wanted to present what we have as a written impact statement. And upon reviewing that impact statement, it only establishes that the minor victim has had to go to counseling and change medications because, and then she gives the reason for that, and it is other family members blaming her for Keegan being in jail. I think on this existing record, that is insufficient to find on a preponderance of the evidence sentencing offense conduct by the defendant caused the serious psychological injury to the minor victim.
That the pivotal ruling the judge isn't denying the victim's pain, saying the law demands proof that the harm flowed directly from the sentencing offense itself. This single decision just lowered the guideline range and narrowed the court's discretion. But as we're about to see, the case is far from over.
So I'll sustain that objection. Then OB4 will be scored at 0 points on both counts. All right, Mr. Indiaki, as to OB10. Yes, Your Honor, it's scored presently at 15 points in both counts for predatory conduct.
Correct, Your Honor. And we would challenge that and believe it's scored at 0 points. Primarily because there's nothing here to establish any kind of predatory conduct specific to these offenses themselves. They're using a committed crime. There's nothing that shows that complainant was, again, this victim was predisposed to sending or receiving, inappropriate pictures by use of a cell phone or through Snapchat. And additionally, as far as the accosting goes, there is, on a lower level, at the 10-point level, there is a relationship between the victim and Mr. Warren. They are related, so there is that. However, there is no exploitation here in the respect that she was with another person, another juvenile, I believe, at the time, and she refused to provide any kind of incriminating photos or anything of that sort. In fact, she turned around and reported the conduct, which is why Mr. Warren is here. And as the statute and the case law discuss, the mere presence alone is insufficient. For those reasons, we would request that both can also be scored, especially for the using. The accosting is a little bit, I understand, a little bit tougher for Your Honor, given that, there is the 10-point difference there. However, especially when it comes to the cell phone portion, we believe it should be scored.
Here comes the heart of the case, OB. 10 predatory conductus about planning choice and targeting. This isn't about what happened in one message, it's about whether the defendant's behavior shows a calculated path toward victimization. And once prior history enters the conversation, everything changes.
Can I ask you one complicating, or one question in my mind as I look at this with predatory conduct? That's defined as pre-offense conduct directed at the victim for the primary purpose of victimization.
Yes.
And the classic, I guess, situation for that is what's commonly referred to as grooming behavior for the offense itself.
Sure.
And here, I'm not sure that there's a record of that until this offense occurred. With the major question in my mind, that your client has a previous juvenile adjudication for victimizing this same minor. That is pre-offense conduct to this offense. And does that constitute predatory conduct, kind of bootstraps into this case at all? Or the passage of time? Does there need to be some sort of continuing sequence of events?
Yeah, that's a very good question. And I think just shooting from the hip a little bit on that.
Okay, I'm thinking from the jump.
Yeah. I think the like you had just mentioned, if there was some sort of, especially with grooming, you know, you notice some sort of friend, they start doing these side jobs or whatever, and all of a sudden they're like a Boy Scout kind of thing, where they establish this relationship, and then over the course of 6 months, 12 months, they start amping up the sexual misconduct, right? I think when we look at this factual record, yes, there is the prior conviction, but there's nothing to show what happened between prior conviction and today. What's the grooming conduct that's the supposed predatory conduct that occurred to lead up to this moment, other than the prior offense? Maybe there was something there, but I think, as you had mentioned, again, we have to look at the preponderance of the evidence, facts, through a victim impact statement, testimony, through an actual oral statement, or perhaps something through the prelim or through the police report. We don't see that in this factual record. So I think that's a very good question to actually establish something to that effect. In this particular case, I don't see where the facts are there. So I would agree based on that. It's another one.
And so you think that OB10 is properly scored at 0, not even the 10 points, because there's no exploitation. So if the accosting is sort of the soliciting or sending of something,
Yeah.
that then by your reasoning that would never support, and those facts would not support the exploitation of a vulnerable victim. I mean, there's plenty of times where accosting is fled down from other behavior. If the accosting is truly sort of soliciting, the without invitation, sharing inappropriate messages or pictures, and the solicitation of them to reciprocate, that conduct itself does not amount to manipulation for selfish purposes to constitute the exploitation.
Yeah.
Understanding that right?
Yes, I think, in other words, I think there has to be an additional fact. So let's say, for example, let's get into a little bit of hypotheticals. I think that might be helpful. I think if there's something, there's predatory conduct where a person goes out and, they encase a playground, or they know that the parents aren't there, or they already have some sort of cell phone, and they choose one family member as opposed to a second family member. That, I think, there's a little different factual scenario there where there is something over and above just the mere relationship or age. Let's say, for example, there's a bunch of children at the playground, and a defendant chooses one out of that group of 5 kids because there's a younger person watching them, and there's nobody to tell us leave or something. I think that sort of circumstance is definitely predatory conduct. Even there's 2 siblings back to back, you choose one because one of the younger siblings has something in their background, maybe a learning disability or something, that they could try to manipulate to their own gain. I think in those circumstances, an accosting would support points, even under OB10, for predatory conduct, or even ageness and so forth. In this circumstance, I don't see there's nothing to kind of give more, I guess, context is the way I would kind of look at it. As to,
Okay. What about, I have one more question for you from the prosecutor. And this is back to predatory conduct, pre-offense conduct. Why can't I parse out the messages so that the messages as it begins in the offense narrative, there's this message back and forth, what are you, he's reaching out, what are you doing? And then he's talking about his move. He's talking about, he's making some references to, I guess he's sort of leading up to, he's got some sexual urges. Before he's asking her to be engaged with any of that, he's sort of leading the conversation in that direction.
sure.
Why wouldn't that constitute the pre-offense conduct for because that's not criminal at that point. So then once there's the criminal event in the conversation, can I count the previous leading up to that moment as pre-offense conduct directed toward victimization?
I don't believe so, because I think it's all part of the same transaction or occurrence, so to speak. I'm trying to think when we see like the Chris Hansen kind of things.
They're doing some things on it because I've scored it in those cases. I've had a couple
Yeah.
of those sting operation cases, and they stop along the way and they get some things, or they communicate with them several different times. So it's more than one conversation.
Yes,
Uh-huh.
I think in that circumstance, our tank would score it that way. I think in this one, actually, too, one of the other factors here is she says, if I'm not mistaken, that she's with somebody else at the same time when he's sending messages to her. And there's not it's not really even a back and forth. It's just he's stating these things to her, and she's pretty much not reciprocating.
Okay. All right. Thank you. I think I understand your position. Mr. Good?
Thank you, Your Honor.
Thank you. I would ask that the court consider the case 2003 case People versus Witherspoon, 257-329. In that case, the defendant, it was an in-person assault case, but the defendant had waited, no other person was present. There was waited till the child was in the seclusion of basement and watched the child and waited for him to be alone before the assault. So the defendant in this case is going to use a phone to commit the accosting. So what does he do? He uses the fact that he's a relative, that they have a previous relationship. She has been previously a victim of his actions. He knows her. He knows how to manipulate her. He waits. She's at a friend's house. He waits. There's no parents around. There's no other adults around. It's only her and another juvenile friend. He then has the setting, any location, no, it's the location of the bedroom that she has in her grandmother's house. He's in her bedroom when he's texting her and doing this accosting. He's laying in her bed to get her attention, to get her to engage in the conversation. He initially sends innocent texts, starts to talk to him before switching into the sexual conversation and sending the sexual pictures. These were all previously, I believe, contemplated pre-offense conducts in grooming her into getting her led into the situation. And so I think the exploitation is properly scored with 15 points.
Any rebuttal argument to that?
Not primarily, Your Honor. Again, Mr. Thank you, Your Honor.
All right. This is presents an interesting question. The statute, statutory sentencing guidelines, offense variable 10 are exploitation of a vulnerable victim, and it's been scored by the Department of Corrections in 15 points for predatory conduct being involved. Predatory conduct is defined.
And that's the trade-off the defense wins OB for, but loses OB. 10, the judge rejects the idea of a spontaneous lapse and instead sees a pattern choices made before the crime that point toward intent. This ruling restores the prosecution's leverage and sets the stage for consecutive prison sentences.
As pre-offense conduct directed at a victim for the primary purpose of victimization. And here, the, the prosecutor, I guess I'm persuaded by the prosecutor's argument presented here today that, there were a series of choices and decisions and actions that the defendant made leading up to the criminal exchange of the, on the text, with his placement of where he was, the, exploiting that relationship, waiting until the victim was at a, outside of the, uh, her parents in her home, and then some of the messages leading up to the criminal, parts. So I think that all of that is pre-sentencing offense conduct. It does involve a series of choices, decisions, and actions. They are directed toward this victim for the primary purpose of victimizing her with the accosting by the computer, which he did. So I think the prosecutor has laid out some pre-offense conduct that would support that score by preponderance of the evidence. So I'll leave OB 10 scored at 15 points, both counts. So I've sustained the challenge to OB4 in the computer crime. So that would lower that from total OB 30 points to 20 points. So that would then be equal to, that would be from OB level 3 to OB level 2. And that would then be, instead of 10 to 23, it'd be 5 to 20. Is my math correct, Mr. Andrea?
I believe so, yes, Your Honor.
Ms. Goodrich?
Yes.
All right. Any other scoring challenges from the defense?
No, it was just over intent.
Any scoring challenges from the people?
Yeah, Your Honor, thank you.
Oh, Mr. Andriaki, any allocution you want to make in the record?
Yes, thank you, Your Honor. I think when we consider this case and Mr. Warner as a whole, unfortunately, there's a significant amount of substance abuse history for him. If you give me just 1 second, I apologize. Your Honor.
Sorry, before we get rolling on that, can you help me calculate what jail credit he's allowed in today? I think I had calculated 239 days back to the October 21st day that we were at. Has anybody done the math to see what credit he's entitled to today?
I have not.
Okay. So let's establish that before we get rolling on the next part here. So up through January 28th would have been 189 days. So now we've got from January 28th to November 25th. Look at the calendar. Let me just grab the date calculator. What I'm going to do is I'm just going to put in the start date at the February 10th, 2025. Oh shit, it's not right. I have to put the days in. I don't get 2 days. I'll start the time. Here we go. All right, I'm using the Michigan Court of Appeals date calculator with a start date of February 10th, 2025, and a target date of today, 11/25/2025, and that says 288 days. Any objection to using that for the credit days?
No, Your Honor, that's the jail list.
No objection, Your Honor.
Oh man, I wish I would have just asked you that. At least I didn't have to do math. All right, I'm sorry. Mr. Andrade, go ahead with the neon.
Thank you, Your Honor. When we look at Mr. Warren, obviously being sentenced on a crime that costs him for more purposes, obviously they're not crimes to be sentenced on. We all understand that the name of them kind of dates them, leads up to them, the sexual registration, everything that goes into that. Mr. Warren's going to be living with this for the rest of his life, including with the registration. the primary thing here when I look at his, first, the letters that were in support, and second, when I look at his adult history and juvenile history in a PSIR, Mr. Warner does not have a significant incarceration period from what I'm looking at. He does have family members in support. I do believe that with 5 to 23 and 2 to 17 on the accosting, um, you know, it comes down to,
I've got 5 to 23 on both.
I scored the accosting at 2 to 17.
I think that was if you won on OB10.
Maybe I misscored it. So class F. And looking at PRVs are 35, OBs.
20.
Oh, you're correct. Yeah, OB 35 and 20. So that's class F by 20. Yeah, you're correct. I apologize, Your Honor. He's 5 to 23.
Okay,
Sorry about that.
that's fine.
Um, it comes down to a prison sentence or a jail sentence, 5 to 23. And I would note, yes, that there has been a previous conviction involving this complainant previously, the victim previously. Mr. Warner, unfortunately, he's a young man, 21, 22 years old, has racked up a significant criminal history. We would request a jail sentence be imposed primarily because all the factors in here have been considered previously. So the fact that he previously had a case involving this complainant is included in his PRV scoring. The facts of the circumstances of the actual conduct here, the score in the movies, he does have family members in support that will do what they can to try to help him stay on the straight and narrow. I believe that, again, he doesn't have a significant incarceration.
This sentence tells a larger story. The court didn't just punish the crime, might punish the pattern. When judges talk about strong medicine, they're signaling something deeper. Public protection escalation and a belief that rehabilitation alone isn't enough. The law may deal in months and years, but the consequences here last a lifetime.
History, 12 months in the county jail would obviously teach him a lesson on these with all that concealed. And I do believe probation and oversight would be appropriate for them too, given the substance abuse problems that he has. Essentially, this case comes down to a substance abuse issue. He does have, two there, was intoxicated and sent these messages. Never sent. So for all that considered, Your Honor, we would request a jail sentence of 12 months in the county jail.
Thank you. Mr. Warner, it's not required that you don't have to say anything today, but you're welcome to. Is there anything you want to tell me or no?
I just want to say what I did. I gone through a really rough time. I used my phone to do something I shouldn't have done. Should have thought to do it not do it.
Okay, thank you, sir. Ms. Goodrich, any recommendations from the people?
Oh, yes, Your Honor, thank you. The defendant is 22 years old with 1 felony and 1 misdemeanor and a juvenile record. He's unemployed with an 11th grade education. What the guidelines don't take in consideration is he has victimized previous victim. Guidelines don't take in consideration that he was on probation for the same offense when he committed this accosting. All at only 22 years old. He has quite the history. The family member reports that we're discussing is the same family members that are giving the victim a hard time, making her feel awful for telling the truth and coming forward. I would ask the court sentence him on top of the guideline range at 23 months.
All right, thank you. All right, after the sentencing offense, he committed an offense, similar offense for which he's on probation, correct?
Yes, Your Honor.
Okay, so he wasn't
I
on
had that
probation at the
backwards.
time of the subsequent, which is relevant. All right, Mr. Warner, if you please stand for the court purpose. All right. Mr. Warner is 22 years old. He's got a prior felony, 1 misdemeanor, and juvenile history. He's here for sentencing on the offenses of accosting a minor for immoral purposes, for sending inappropriate messages and photographs to her and asking her to do the same, and using a computer to commit that crime. The advisory guidelines are scored at 5 to 23 months on both counts. There is discretionary consecutive sentencing that's authorized by the computer crime statute. In this case, Mr. Warner's history is what's most concerning. He has a juvenile adjudication for accosting and indecent exposure in 2016 involving the same victim as in this case when she was 7 years old. And now as a teenager, he's victimizing her a second time. And then also, after this offense, the offense date for this case was October of 2024. In March of 2025, Mr. Warner engaged in similar conduct in Emmett County. A different victim, still related to him, and about 12 years old. And he's been sentenced to probation with a jail term. I think the prosecutor makes a good point that the guidelines, although they take into account the prior or subsequent convictions, they don't take into account the disturbing patterns of similar sexual crimes, now 3 of them. They don't take into account that he's victimized more than one victim. And they certainly don't take into account that he has now victimized the victim in this case for the second time. Once when she's 7 and then when she's a teenager. Now, this shows that this is beyond an alcohol problem for Mr. Warner. He has a serious issue with being a predatory sex offender, victimizing minors that are related to him. More than one, and more than 2 victims, and one of them victimized twice that we know of. There'd be a pretty good argument that those factors aren't taken into account in the guidelines and there'd be grounds for an upward departure. But given that he's got no prior record, these offenses didn't involve actual contact with them. I'm not sure that I'd want to do a departure sentence. I certainly do agree with the prosecutor that I think upper end is proportionate sentence here. So there's $136 in state costs, $130 in crime victims assessment, $350 in court costs. Mr. Warner has been registered with the Sex Offender Registration Act. You have to comply with that. And on the charge of accosting minors for immoral purposes, I'm going to commit Mr. Warner to the Michigan Department of Corrections for a term of not less than 23 months, nor more than 4 years, with credit for 288 days previously served. And for the using a computer to commit a crime, I'm going to commit him to the Michigan Department of Corrections for a term of not less than 23 months, nor more than 7 years. And I'm going to give him 0 days credit on that and exercise my discretion to impose consecutive sentencing. I think that strong medicine is required here, given his disturbing pattern of victimization as a outlined. So that's the sentence of the court. Mr. Warner, you're allowed to, you may file an application to appeal your conviction and my sentences are both. If you wanted a lawyer appointed to you, I would do that. If you requested within 6 months of today's date, we're going to hand you a piece of paper explaining that appeal right and ask you to initial 1 copy for us. So we have a record we gave it to you. The other one is for you to fill out if you wish to take an appeal. All right, good luck to you, sir. Thank you, Mr. Andrew.